All right, good. Ooh. So the mic is working. So welcome everyone to our meeting. Welcome to those of you, all three of you watching at home. And we're going to start our meeting. We have a few people coming in. And just a couple of notes. We're going to, the agenda is going to proceed as written. We have no additions or subtractions. Just a reminder that we're televising the meeting and we're recording the meeting. So just be aware of that. And also, if you're going to speak, you need to be on a live mic, and that goes for the board members. And also, if you're down there, are those two mics, and this one also works if you prefer that one. We have no public hearings scheduled for tonight, and our next meeting is September 2nd. And does anybody on the board have anything they want to talk about before we get started? Okay, so we have two items for board discussion. The first is Shore Farm Townhomes, Clinton Corners Road. Is anybody here for that? Hello. Do you want to sit at the table here? And first of all, just let us know who's on the team. Just identify yourselves, and then we'll go from there.
Am I live now?
Yep.
Live. Perfect. So I'm Natalie Quinn with KARC Planning Consultants, and I'm joined this evening with my colleague Jocelyn, who's going to be Vanna for the PowerPoint, and then Ashley Borza from MJ Engineering.
Hello.
So this is our first time presenting to the planning board, so I'll start with a quick kind of overview of the project, and then we're happy to kind of just answer any questions the board has.
Just for sound quality, push the mic away from you. They're really sensitive. Yeah, how's that?
Here, is
Try
this
that.
better? Oh, that sounds better.
Okay.
You can hear me? Okay,
Yep.
Great. Okay, so here's the project site. The project site, it's on, it's just off of the Taconic, off of Clinton Corners Road. The eastern property boundary is the municipal line with Town of Washington, so it's right there on the corner. It is a 70-acre site, and it's currently located in the CR1 zoning district. And I'm sure you're very familiar with this, but the intent of the district, one of the intents of the district, is to provide diverse housing while also preserving agriculture. And that's really fundamentally where this project comes out of. Andy and Sam Shore, the Shore family, own this property. They use it for agricultural use right now, for hay farms. There's some bee keeping on site. And in order to help them maintain this land and keep the farm in the family, they're looking for some other way to generate a small amount of income from this land. So what they're looking at is a modest addition of 16 units and a kind of clustered multifamily development, which we'll walk you through. But I just really wanted to point to, I think the intent of the zoning district is really important, and that's kind of where this project was born, is how do you keep the agricultural land in the family and operating and help yourself pay for all those taxes and keep that land.
Did you say 16 or 12?
16. Sorry.
12
4,
or
8, 12. 12.
Okay.
My apologies.
Thank you.
Apologies. So in addition to being in the CR1 district, there's a small southern portion of the property that's also in the floodplain overlay. And then based on, I couldn't find a map of this, but I think based on the description, I believe we're also in the Taconic Parkway view shed, just from distances. So next slide. So we're going to zoom in, so you don't expect you to see all the detail here, but we did want to give, okay, if I need this, I will use this. So the site, I appreciate it. Right now you're seeing two sites here, right? So you can see the white line. Oh, it doesn't come up in the middle.
Brandon, are you able to focus on the map?
Yeah, it's probably still gonna be a little blurry. But...
Okay, thanks.
And these were also, this is in the submission materials. The only thing we did here is we did change, we tried to highlight coloring of the wetlands a little bit to help differentiate, but I'll walk you through that. So what we're showing here is two parcels that are owned by the Shore family. So both parcels are owned by the applicant, but the one on the east side is obviously in the Town of Washington. So you can kind of see the white dotted line down the middle through that largest wetland, which is dividing the property. And so we are focused on the property on the left-hand side of the screen. So as you can see on this site, we are working with existing wetlands on this site. There are wooded areas, and then there are active hay fields that are used by the family for farming. So where, the site and where we selected the proposed development to be, there was a lot of thoughtful discussion about that, and I'll kind of walk us through that. But next slide, we'll zoom in a little bit closer. Oh, sorry, go back one. This was in the packet, we won't get into too much here, but we did give you kind of site conditions, and here they're all overlaid, but we were looking at, you have a map with slopes of greater than 15%, soils, we have the DEC informational wetlands, and then we also have some delineated. So the DEC informational wetlands are the darker blue, right? So those are the ones from the DEC map. Where we knew we were going to be coming close to the wetlands with the proposed development, we had a wetland specialist go out there and specifically delineate those boundaries. So those are the ones shown in the turquoise kind of lighter blue. And again, next slide, we'll zoom into that a little bit more so you can see that more closely. So 12 units. 1, 2, in 3 buildings, so 4 units in each building. These are multifamily, right? Because this is all one site. We're not subdividing into townhouses, but they are townhouse style in that each individual unit will have their own entrance. I'll kind of show you an elevation later on, but each unit has their own entrance. They have a first floor and a second floor. And so it will be maintained on one single lot here. We're not proposing to subdivide. I'll show you just kind of, we'll come back to this, but I'll show you what they look, some initial sketches. So here's front elevations. The 2 outer units are 3-bedroom units with garages. And then the 2 internal, inner units are 1-bedroom units, right? Without the garages, there's parking in front on the site plan. And I think the intent for that was to also add diversity, which is kind of cited in the code of having different types of residential options, right? So you can imagine the 3 bedrooms are more for families, whereas the 1-bedroom units could be for couples or individuals. Next slide. So this is just the rear elevation. You have a second means of egress for the internal units, and then the second means of egress for the other units is kind of through the garage in the front. And then, so we started going through the wetlands permit, and I know there's a lot of conversation in the wetlands permit about describing why the activity cannot be located anywhere outside of the controlled area. So while I talk through these points, Jocelyn, if you could just go back to the 3rd slide, I think the full site plan so we can kind of see that one, right? So the proposed location, we are taking advantage of an existing driveway and an already existing wetland crossing that was put in years ago for the tractors to be able to get over to the fields on the other side of the wetland. So rather than create any new crossings anywhere, we wanted to maintain the use of that existing crossing rather than do a second. This location, the proposed location, also avoids disturbing and clearing the existed wooded areas. You can kind of see it in the underlying aerial that to the north in the center portion of the property is existing kind of woodland area and natural existing habitat. So we're trying to maintain that as much as possible. So you'll see we have some images that I'll go to at the end of the PowerPoint that show that we're trying to work within kind of existing cleared areas. The proposed location also offers natural screening and privacy from the road. So the property or the project could have been located closer to Clinton Corners Road. It's set back for 2 reasons. One, because those are active hay fields that are farmed in the front along the road, and then also privacy both for these future tenants, residents, as well as residents on the road. Using this more internal location provides that screening and that privacy. This is a underutilized portion of the site. It's a former, not a commercial orchard, it's just where they planted some fruit trees historically, they weren't with pesticides or anything like that, but there's fruit trees, and they're not using that for the haying or the bees. So this portion can be better utilized for housing. And then also this location offers soils that are ideal for the proposed sanitary systems for the various septic operations, as well as the wastewater, the stormwater. So I think that's it. I think we can go to the end of the presentation, and we'll just click through some slides in case you haven't been on this property. So this is kind of looking at, you can see up in the upper right-hand corner, we're kind of showing you on the site plan what vantage point you're looking at with that with that red line. So you're kind of looking through the development site towards the nearest neighbor here that is, again, nicely screened by existing trees. This is from the road, the existing road that would lead to this development is kind of looking into the adjacent property. Again, you're kind of looking towards the house, but you can't see it there with the existing trees and screening. This is from the road. Again, we were trying to show here that this proposed development will be set back and hidden from the road. So again, there's another kind of existing tree buffer there that will be maintained. And then this was just kind of another vantage point of trying to look through the creek. So that's general overview. I think the other thing you have in your packet is we did start to do the EAF. So we did a short form EAF with all the kind of attachments to start to go through habitat, species, wetlands, all that information. So that's where we're at, and I think our goal for this evening for the sketch plan is to just get initial comments. If there's or if there's additional reports or studies or things like that that are required to make a complete application. And then otherwise, just general feedback.
That's great. Does the board have any, we're going to get to Adriana's comments, and I want to focus on the zoning issues in particular, because that's something we need to figure out. But does the board have any general questions on the presentation? This is a pre-submission discussion. They haven't formally applied yet. So anything is really, there are no really bad questions when you think about it.
No, anything else you want to see or, yeah.
Or would you like to hear from Adriana first before you? Do you want to just, do you have some things that you want to cover? And again, I do think the zoning issues you highlighted in your memo are important for, to resolve first. And then obviously there are a lot of details that we'll get to at some point, but.
Yeah, and we don't have to cover the
And you-
standard.
Maybe you should use the mic.
Yeah,
you
just
gotta- yeah.
not too close, but not too far. It's the Goldilocks situation here. Okay. Yeah, so we don't have to go through the site plan requirements. That's pretty easily accessed. But we did want to highlight a couple of things. So within the multifamily supplemental regulations, there's an open space provision that is a bit challenging to interpret without a minimum lot size that meets the criteria, right? So we understand that you guys were not looking initially to subdivide the parcel, and we had talked about potentially having some kind of a deed area or a clear demarcation on the plans as to what portion of the area would be dedicated to this multifamily use, to the users of the housing versus the agricultural use.
Okay.
But 250.62.b subpoint 10 requires an open area of 40% of the gross lot area to be provided for use by the tenants. So there's a little bit of a complexity because, so the site itself is 70 acres. It's part of a larger deed lot that spans the town lines.
Yeah.
My assumption is that we'd be still focused on the 70 acres because that's what the zoning regulates.
Okay.
But on a 70-acre parcel, you're looking at dedicating 28 acres of open space to the 12 units of townhome,
Yeah.
where a minimum lot size of 12 acres is what's required. So that would yield about 4.8 acres of open space as a requirement. So because it's a percentage of the gross lot area, you guys have space to play with that, but I just, I wanted to highlight that because I'm not sure how the town would interpret this regulation absent the zoning. A strict interpretation of this zoning provision, absent a subdivision, would be that 40% of the 70 acres needs to be set aside for open space, which is a good chunk of land, and I don't really know how that would be confirmed. Is that a note on the plans? Is it a deed restriction?
Is it a fence?
Is it a fence?
And that's space usable by the tenants, so it presumably couldn't be farmed,
Yeah, right.
because the tenants have to have access to it.
Yeah, I mean, I guess I also thought there was a question about whether that section, the multifamily supplemental regulations, would even apply to a project that is not a subdivision. I guess we never
No.
received a zoning determination on that.
Okay, so, I did not look at the cluster regulations.
Okay.
Because I think we did, kind of rectify that. So this is not a cluster subdivision, but it would qualify as a multifamily development.
Okay,
And so that would fall under 250-62. So there are supplemental regulations for multifamily development. So that would be kind of what we would be referencing.
Okay. and then I guess does it play into the factor that the disturbance, like if we were to try and delineate, right? You can see a delineated area here of the disturbance that is proposed for this project. And that is 3.5 acres, but I guess we had never thought that that those sub-regulations were gonna apply, so you're saying the minimum lot size of this has to be 12 acres?
Right,
Okay,
yeah. So you can't go less than 12 acres?
Yeah.
Right now, you're fine because you're on 70. But the 40% of the gross lot area as open, it says an open area of 40% of the gross lot area must be provided for use by tenants. And so it doesn't really specify what the use is. Does it have to be programmed? Is it simply just open space?
Is it just not fenced off, like prohibited from going
Exactly,
on there?
not prohibited.
Because the 10, right, seems like it's trying to prevent a situation where you're overdeveloping a lot and there's no open space.
Right.
Not that you're having a giant lot and you've got to give a ton to the house. So
Right.
it's,
Yeah, so I don't know even, I mean, I guess I would defer to the,
where does it, sorry, where did the 12 acres come from? What's that number?
that's the minimum lot size that, that you can put multifamily, 12
One
multifamily
acre
units on.
zoning.
Got it, thank you.
And then similarly, so playing into that, I think a lot of this is about interpretation, right? So is a subdivision even required, or can the board, I think what's confusing is that it does refer to the gross lot area, and that is typically a surveyed parcel. But then there's section 62B11 about recreation fees will be charged unless the dedication of land or construction of recreational facilities is provided. Now, 10 references a required dedication of land. So I'm not really clear. I think we need some clarification on how we work through that as well.
okay. From us, or do you want that from,
I think we need it from Jeff.
okay.
And then the last point that I wanted to highlight, okay, so this, I believe, was part of cluster development, but I brought it up because it kind of relates to our consideration of all of these moving parts. 250-12B2 states that partial subdivision of a parcel is permitted to accommodate landowners who do not wish to subdivide their entire property. However, in the CR1 district, unless the cluster requirement is waived by the planning board, all subdivisions that do not develop the maximum allowable number of lots or dwelling units on a given parcel shall be created in accordance with an overall cluster plan. So I kind of just noted that this provision kind of supports the suggestion that the townhomes could be and should be subdivided from the remaining lot, because you're not proposing 70 townhomes, you're proposing 12. And therefore, not developing to the maximum allowable number of units would, warrant a potential subdivision. Now, that doesn't mean that you can't still, I would say, can't still do agriculture on that land as long as it's open for the tenants. So,
Okay.
right, so you could have an easement or an agreement of use
On the 12 acres?
on the 12 acres,
Oh, okay.
right, to maintain that contiguous property legally. And there's no requirement that that parcel be sold, it can remain in common ownership.
Right, okay. Do you think your clients would be willing to consider a subdivision, or is it even feasible? I mean, I'm just throwing it out there.
I don't think we haven't really considered that. I mean, this is kind of the first that I've heard that this section's gonna be applied, so I think it would be helpful if we could just see the initial memos and sections and be able to look
Okay.
at that and then discuss that. I think that would be most helpful.
Okay.
Do you have Adriana's memo yet, or I don't know if that was circulated to you?
I don't have
The
that
comment
yet.
memo? Okay, but can you send them
I'll
a
send it to
copy?
you. Yeah,
Yeah.
I can send it to
Okay.
you.
Okay, that'd be helpful.
Yep.
But I think to Justin's point, all these regulations seem to be thinking about a reverse situation, right? Where someone's trying to cram something into a small site.
Right.
Instead of, someone's trying to put a small development on a very large site.
Yeah, I'm just, the open space thing I'm struggling with, because it's not really variable, apparently. It's 40% of
The gross lot area.
70,
Can you get a variance?
I suppose.
Yeah, they would be able to get an area variance for that. It's a measurable number, so.
It
Yeah,
just
that's
seems
an
like the
interesting
law is
point.
written is just not
Sorry, I didn't hear the
sensical
point.
for this.
They mentioned an area variance from the 40%.
From the 40%.
If it's determined that that applies, right?
That-
Like,
right.
Yeah, okay.
Um,
Was that not the one that had the ability for the planning board to, I'm trying to respond to things I haven't read the
I
language for.
understand,
Yeah,
yeah.
So I don't know if that was the
Sorry.
one, there was something that allowed the planning board to make a determination, so.
I didn't see anything
Okay.
in the special use permit criteria that actually does allow the planning board to waive special use permits, special use permit criteria themselves that are written into the law, and I believe that the way this was worded, I didn't quote it directly in my memo, so I'd have to look up the actual language, but I don't think that it was a discretionary language, yeah.
Currently, the 12 units. Currently, the 12 units that you're building in that little green pod there at the bottom, what total acres did that encompass?
That is 3.58 acres. That's including the road, so it's like the whole green where the road and then the development is 3.58 acres on the site. But that was just, we were identifying that as area of disturbance, right, for purposes of kind of land disturbance, so that wasn't meant to be a subdivision line or anything like that.
So is the easiest way possibly to subdivide off the 12 acres with that as a right-of-way into it? And in that 12 acres, could you then get your 40% of open space and not affect, or not have the other 58 acres come into play in this?
Yeah,
Presumably with a subdivision.
That sounds like
That's
how
the
I would
theory,
do it.
yeah,
that's kind of what we're.
that's one
trying to- yeah.
potential outcome.
Yeah, I think that's an option, we'll just, I don't know enough about the property and the, in terms of the applicant wanting to maintain for whatever reason, so I'll discuss that, definitely. It seems like that could be an easy option, as long as that's working on all other realms in terms of the functionality of the land, taxes, property rights, stuff like that, so.
Okay.
Can definitely
It
look
just seems easy in that you would just chop that part off and then obviously create the right-of-way or the easement to always enter into that, and it doesn't affect the rest of the parcel at all.
Yeah, we can look into that.
And then you're not legislated on the rest of that parcel as well.
That's a good point, yeah.
And I'm looking at the statute. I mean, it looks like what is usable open space and where the 40% is on the lot would be kind of at our discretion. So we might have some flexibility there.
Right.
Adriana, I think another possible approach, right, is, because it requires both a special use permit and site plan approval, and as you mentioned, in the special use permit section, the planning board does not have the authority to waive those requirements. However, in the site plan approval process, they do. And so if part of this is looked at as the site plan side of the approval, because it's dealing with how the site is laid out, is that potentially something that could be waived or modified by the planning board?
It's an interesting question, Jeff. Typically, that waiver provision that you're referring to is usually referencing the required elements of a site plan, not the supplemental regulations
that's a
around
good
the
point.
use itself.
Yeah, that's
So, how do we want to proceed with just figuring this out? It sounds like maybe the
I
consultants
think
need
if
to
we
talk
can,
with
yeah, if we can get
Jeff.
these comments and then any other official zoning determinations in
needs to
terms of
weigh
use
in,
and everything like
okay.
that, I think with that information, our concept plan, we can kind of go back to the table and finalize an official submission and know a
Okay.
little bit more about whether we can meet these regulations or if we're proposing some kind of variance or something like that. So I think it would be helpful to get all the information that we can
So we're
repackage.
fine with working directly with Pete, Adriana, Shane, our lawyer, if necessary, obviously Jeff,
Yeah,
to work this out, without, if you want a board member involved, Jim's the board member, and we can certainly do it that way. I mean, what, did you have, was somebody, I cut somebody off. Somebody gonna say something? Okay. Did the board have any general questions not related to zoning on the project? I mean, we should all go over there at some later date to be determined for a site visit, because I think we all want to see how it's gonna,
Yeah.
how it's gonna
yeah,
look,
absolutely.
Are these
Yeah, the
rental
feel of it.
units or for sale?
rental.
Sorry?
These are rental units?
Rental.
I-
Yep, that's the intent.
I wanted to come back to the cluster development thing, because that was really the determining factor in this not being cluster development, because in cluster development, it requires that each unit is owner occupied, right? So these being rentals have to fall under multifamily, not cluster.
Okay. And I think we said their market rate rentals, or that's going to be determined, or, okay.
Yeah, that's the intent.
okay.
I guess the only other thing that I wanted to, just to help MJ in terms of like building out the site plan and everything. So I wanted to make sure that it was okay with the approach that we took, because I know the wetlands permit is something we'll have to go through at this level. And then if we meet the local wetlands regulations, I think we discussed that the official JD and stuff like that from DEC can be conditions of site plan approval. So, what we did here was we delineated the wetlands that are obviously going to be potentially immediately impacted by the project. I just wanted to confirm that that was an okay approach, that we didn't need to extend that delineation beyond,
Is that a 100-foot buffer?
yes.
I think that's fine then.
Okay.
I would think that would be, I would defer to the board, but for my purposes, I think that's appropriate.
Good. Let's,
I do
have
just
you,
want to note, we did receive a short form EAF. This is on an ag parcel though, right? Like it's in an ag district.
It is in the ag district, yes.
So that just kind of messes with seeker in a funny way, and so it's actually type 1 action. So we'll just need a full EAF.
I thought is there a reason? There's a threshold that we didn't meet.
It's any unlisted action that includes a non-agricultural use occurring within an agricultural district exceeding 25% of any threshold established on the type 1 list, and the threshold would be 10 acres of disturbance. 25% of that is 2.5 acres.
Okay. Okay. So type 1,
And that really only changes that we have to circulate a notice of intent, and you need a long form, full form EAF.
just on the wetlands point, are you going to submit for a DEC jurisdictional determination at some point, or?
yes, I believe in that I think that's what we had been discussing, that process is taking a little bit longer than,
In 90 days?
the 90 days with the new regulations. So something like that, I think what we did was delineation of them, assuming they are DEC regulated, basically, right, is what we're doing. And so functioning within that, and then that official process with DEC would be done as a condition of approval, I think.
Were you gonna look at the general you mentioned you were gonna look at the general permit requirements, or were you talking about the local permitting requirements?
I was looking at the local permitting requirement, at the town's wetlands regulations.
Because there is a draft general permit, actually, where it might have been adopted, TBD. But it's, I think, a helpful reference for your team just to look at it.
Yeah.
And see how the DEC would factor in this type of disturbance. The board might be curious about that just as you move forward, because the permitting would be a condition of, like, a a development permit.
Yeah.
Okay. I mean, but the, the first phase is the parcel determination, right?
Yeah, yes.
Which
the
you can
first-
do, they don't even need to know what the project is, right?
Right.
Okay. Isn't that something that should be started as soon as,
To submit for the JD, for
Yeah.
DEC? Yeah.
just for the parcel?
Yep.
Okay,
Has that been done?
I'd have to check. I'm not quite sure if our wetlands guy did that yet.
Okay.
Yep.
Yeah, so that's
Okay.
3 months.
do you want me to, yeah?
So as far as engineering items go, you know, water and sewer is that's gonna be covered by the county health department. Stormwater, like management, shouldn't be, an issue here. But, I did have a question on, two things.
But move
How
the
come
mic
there's-
back a little, Pete, will you? It's
Away?
echoing a little bit.
Okay.
Thank
How
you.
come there's such a long, like, access road to get in here? I mean, I believe there's an existing, farm access road, but, I mean, there's plenty, a sight distance there. Was there any thought to moving it so you didn't have to build such a long access road?
Yeah, so the access road does exist, right? And so we're utilizing the existing access road. And this site, when you got into the images and stuff, this is where it kind of opens up and there's minimal clearing or anything that would have to happen for this site. So both that the development is kind of set behind natural buffers at this location, the road already exists there, and that we don't have to do any additional, we have to do minimal clearing to, like, this area is already kind of an open field area. So that's why this location, so that access road already exists. I think that's something we'd like to discuss too, whether that could be maintained as gravel. Like, obviously, we're proposing 24 width the whole way through. The crossing right now, the wetland crossing is more than 24 feet, so we would just kind of grade out the rest of the road to meet that 24. And I think the intent would allow it to remain as permeable as possible. So if maybe there's an apron at the beginning, but the rest of it remains gravel, or whatever medium we could use, I think that would be ideal.
I mean, I don't see that being an issue. I mean, well, as we get further along, this will get referred to the fire department, so obviously they're gonna have some comments. They'll, depending on, you know, the length of the road going in there may be a need for a pull-off, or two. I think they require pull-off every 500 feet. But the other thing was, and I don't know that it's gonna apply here, and again, we'd have to talk to the fire department on this, is, I know one of your first, site plans had a secondary access to the property, next door, and then that's since, you know, been taken off. You know, I don't know that, you know, a secondary access is really necessary here, because, again, we'll have to talk to the fire department, but, you know, the road is through pretty much an open, field. There's not, if I remember right, going by, there's not a lot of trees there, where, if we had a bad storm, like we had, you know, July, you know, the 3rd or the 4th, where there's trees down all over the place and the road was blocked, and God forbid there was, you know, a medical, you know, like, emergency back in there with one of the unit owners, and they couldn't, you know, like, get there. I don't know that there's anything here that would create some kind of a, I don't say natural, you know, like, disaster, but,
Yeah.
you know, isn't like there's like a bridge there, that if the bridge like went out, so I think it's pretty open, so I don't know that, you know, a secondary access is critical here, but that's something we'll talk,
Talk with fire.
yeah, we'll talk
Okay.
to the fire department about.
Yeah.
That was it, just initially.
Okay. Any other general questions from the board members? Concern, nothing? Okay, so have we given you enough guidance on how to
Yeah,
proceed?
I
at this
just want
point?
to give Ashley, did you have any questions for engineering or what you guys had been working on? I just want to make sure I give you, if you had questions for the board.
No, at this moment, I don't believe so. Now, if this location has been okayed, and obviously we can do more investigations, this would be the time where we would do soils testing or test pits or borings to test the soils for the sewer locations and the stormwater. And that's, if we're going with this location, we can definitely proceed with that.
Yeah, I guess that would be a fundamental, so I think we can look into the the zoning regulations, kind of division of property and differentiation between the ag lands and the multifamily. But I think, going back to the local wetlands regulations, we did want to get general, like, does this feel like an okay area to the board, or is there concerns about this location? Just, this was what we identified as avoids the most wetlands, avoids the most tree clearing, utilizes the existing roadway, like I said. But I think that would be helpful for us to kind of finalize the site plan to make sure that there wasn't any major concerns with this location.
I don't know enough yet to make that, I don't know how anybody else feels. I'm not sure I know enough to sort of make that decision, but maybe the consultants can look at that a little more closely, if you think that's going to be an issue. In terms of wastewater, Pete, these are septic systems, so this isn't like one of those treatment plants that's, okay. So this is just Board of Health?
Subsurface septic.
Okay.
Yeah.
I assume, it's gravel.
Yeah, and 3 separate ones, each building will kind of have their own septic hookup.
Okay.
Yes, and one thing I would like to reiterate is that this area has the best soils according to online mapping along the road, so A soils along the road. There are some areas that are D soils, and we'd like to avoid those, so those would be the clay type soils as opposed to sandy gravel areas with great infiltration rates.
Okay.
So to go to your point about is that the proper location, the middle, kind of looks like a shark fin, if you will. And then it's delineated by the dash blue line or purplish blue line.
Yeah.
So it continues down to the proposed building site. Why does that continue down instead of encompassing like the one in the lower right-hand corner does? Follow my question?
Yeah, so
Like
for
a-
the dark blue, the informational DEC wetland, why that 100-foot buffer is not wrapping fully around the DEC. So I believe it's following it then merges with the other, with the
The federal-
light blue wetland. So you're kind of keeping the 100-foot away from that kind of cluster.
And with that, with the aqua color and the purple color, you've obviously met your setbacks or your buffer zone, is that correct?
Yes, of 100 feet from those,
Right,
yeah.
okay.
Yeah. Yeah, again, assuming they're DEC regulated and they're gonna want us to be 100 feet out of them, that's why we kind of started from that point.
I think what we, in terms of the wetlands, and we're relatively new here as well, so you guys can advise me on how you would like, how you typically file these with the zoning administrator, but the local wetlands law does have a list of items that should be submitted. Most of them will be submitted with your application
Yeah.
anyway. But I would just recommend making sure that all of those have been submitted. And then really there are just standards for the discretionary standards for the planning board to consider. And most of them, there's the waiver provision as well. And so, for the board's, use, most of them kind of refer to this conversation that we're having now, where are there no other alternatives to avoiding wetlands? And I think what we're seeing here is that they're using existing disturbed areas and an existing culvert,
Yeah,
right? So the actual disturbance area may be a lot more minimal than a brand new disturbance and installing a culvert and things like that.
Yeah, and the new DEC procedure is, obviously it's new to everybody, and as a general rule, we've typically deferred to DEC if they have jurisdiction, which doesn't mean that we do nothing, but it just means we typically track whatever they,
we're gonna have to go through that permitting
and you're gonna have to do
process,
that anyway,
yeah.
so
Yeah,
I would try to get a determination, as soon as you can, and then we can,
We just got a positive determination, a parcel level determination in Ulster County. And they moved pretty quickly from the positive determination to the field verification.
okay.
So I think that now that I'm hoping that now that their initial, bottleneck has eased,
Yep.
they're able to process things a little bit quicker.
Okay, anything else on this one we need right now? I'm sorry, I didn't catch that. Yeah. Anything else? The board's done, right? Okay. Do you need anything else from us? or-
Nope, I think it was helpful to start the conversation.
Definitely.
And, yeah, this is helpful. So now we can kind of finalize the package and get that in front of you guys.
And if, just get back in touch with us if you want to get back on an agenda to have a more fulsome discussion, we'll be
Okay.
happy to do that.
Okay, perfect.
We're here
And then
most
do we want to
Tuesdays.
arrange a site visit after maybe we've finalized kind of a submission and then do a site visit? Or is it helpful to
I
do
would
that sooner rather than later?
Wait until it's a little further
Let's figure out the
along.
zoning thing, yeah. Okay.
So are they gonna do the subdivision or the move,
We don't know yet. They got to figure it out.
or they could submit both to show?
Sorry?
Arlene was just asking which way you're going in terms of subdivision or not, and I said they don't know yet.
Yeah, I think, yeah, we were just asking to kind of get the zoning analyses from the consultants, and then we can take those and
I was
we'll
gonna
look
say,
at our
you could-
options.
You could probably wanna show it both too, this way, weighing in.
Yeah. Perfect.
Okay, great.
Great, thank you so much. Appreciate your time.
Happy- All right, next up is Six Senses Board discussion, and I'm going to,
Well, how about Kelly goes in the middle then?
yeah, here.
Ooh, excuse me.
Good, how's it going? Yeah, you like me looking for it?
Yeah, I agree.
Yeah, I was gonna wonder.
Oh, okay.
I don't think we have enough to share.
There you go. Thank you.
So.
Is there food for
so-
the consultants, or? It's like, I didn't realize that this was like bring
depends-
your own food night.
Depends how nice you are to us. Okay, is everybody done with the cookies, or how?
Come on, I've gotta submit it.
What about me? Yeah, I'm okay, I'm seriously good.
Okay, that,
That's okay. Mr. Chairman, while you're passing food, I'll just do a formality, if that's okay. We recognize that there's a new planning board member, and so we chose to not print the entire package of materials that we've submitted for this project, but we did print each of the cover letters because I think they're very descriptive, and we provided a flash drive of all of the submissions. So I just wanted to hand that to you, if that's okay, and then
Okay.
that can get distributed.
Jim, I think they're talking about you.
Jim, but
You have a whole
he's
bunch of-
familiar, he read a
You-
lot, that's fine.
We just have to-
You have a whole
we
bunch
want
of
it on
stuff,
the
but don't read it yet, because I have to do something first.
Okay.
So this is on the agenda for a discussion regarding, well, I'm gonna make a statement, that I'm gonna read it, because I had to kind of try to organize it in a rational way. So let me just go through my statement, just of some background information, because it's been a long time since we had this matter on our agenda. And then I'm going to set it up for board discussion, if that's okay. So if you might want to send out for coffee, because it's not, it goes on for a little bit. But anyway, here we go. So since it's been a while, and this matter has been before 5 other boards in 3 different towns since we last met on this application, I thought I would summarize the relevant procedural history and then explain why I put it on tonight's agenda. In the interest of time, I'll be focusing only on the pertinent history and will not attempt to summarize everything that's happened in the last 16 months or so. Board members will recall, except for Jim, who is not here, that certain zoning rulings issued by the acting zoning administrator in Clinton relating to this matter were appealed to the ZBA by a group of concerned residents. The ZBA issued its decision on the appeal on June 4th, 2024, and it covered a number of issues that are not relevant to tonight's discussion. We are, in fact, concerned with only one of those issues tonight pertaining to road access to a parcel owned by the applicant in Clinton. As background, the applicant owns several lots, including a large parcel in the town of Clinton that is the site of most of the proposed development in connection with the conference center application. The Clinton parcel does not have direct road frontage, and accordingly, access from Route 9G to the site must be afforded by a separate, smaller parcel that is in the town of Hyde Park. There's an existing conference center on the site served by a driveway over the Hyde Park parcel that was permitted by a special use permit issued in Clinton in 2005 and amended in 2017 to allow up to 44 guests. The Hyde Park parcel is subject to the zoning regulations of Hyde Park, and the applicant requires approval for the proposed access from Hyde Park, including construction of a second driveway for emergency access. At the time the Clinton ZBA considered the residents' appeal, the Hyde Park zoning administrator had ruled that the Hyde Park parcel could not be used for access to the Clinton parcel in connection with the proposed development because the conference center use was not permitted in Hyde Park's Greenbelt district, which included the Hyde Park parcel. Note that the Hyde Park zoning administrator did not restrict access over the Hyde Park parcel utilizing the existing driveway for the previously approved conference center use already on the site. Because Hyde Park had not granted access for the proposed expanded conference center use, the Clinton ZBA ruled that the access requirements set forth in zoning law section 250-24 had not been met, and accordingly the application could not proceed before the planning board. The language they used is important, so I'm going to read directly from it. Quote, "Our interpretation of the town code is that until legal access to the project site has been restored by the town of Hyde Park pursuant to either the town of Hyde Park ZBA reversing the Hyde Park denials or the town of Hyde Park zoning administrator rescinding the Hyde Park denials and thereby permitting access over the Hyde Park parcel, the amended application is not in compliance with section 250-24 of the town code." And they went on to say, "We hold that until such time as the Hyde Park denials are reversed pursuant to a final non-appealable decision, the amended application is not in conformity with the town code and cannot proceed to the planning board for review." And I should just note, after our ZBA issued that decision, the Hyde Park ZBA affirmed the ruling made by their zoning administrator denying access. Now it gets really complicated. The applicant subsequently brought Article 78 proceedings against the towns of Clinton and Hyde Park, challenging the various rulings made by their respective ZBAs. In response, Hyde Park passed a local law amending its town code to, in effect, create a legal presumption in favor of allowing access across land in Hyde Park to serve uses located and permitted in neighboring municipalities, even if such uses were not permitted in Hyde Park. The local law also stated, quote, "Any determination made or action taken by either an administrative board or an administrative officer prior to the adoption of this local law and which does not comply with this section shall be deemed null and void and without force and effect. The local law provides, however, that Hyde Park residents may challenge proposed access ways or roads by submitting a petition to the Hyde Park Town Board, demonstrating that the proposed development, quote, offends public morals or endangers or injures property, health, or safety of Hyde Park residents." Shortly after passage of the local law, the applicant entered into a settlement of the Article 78 proceedings with the towns of Hyde Park and Clinton. Pursuant to the settlement stipulation, the parties agreed that, another quote, "The access drive and the proposed modifications to it on the Hyde Park parcel are permitted to serve the conference center use in Clinton as of right, which is a use that has existed since 2005, subject to Local Law 1 of 2025. And the stipulation further provided that this so-ordered stipulation constitutes a non-appealable decision, as that term is used in the June 4, 2024 decision made by the Town of Clinton Zoning Board of Appeals regarding access to the plaintiff petitioner's proposed use of the property within its jurisdiction. The parties acknowledge that there is no right of appeal from this so-ordered stipulation, and I would note that the stipulation was entered into by our town board, but that neither the Clinton ZBA nor the planning board were parties to the litigation or the settlement. So where are we now? Sorry, just got to, there's a pending article, thank you. There's a pending Article 78 proceeding that was brought by a group of concerned citizens and the town of Rhinebeck against Hyde Park and Clinton, challenging, among other things, the passage of the local law in Hyde Park and the resulting settlement. The court in that action, however, has not issued a restraining order or stay affecting proceedings before this board. In addition, a group of Hyde Park residents has submitted a petition pursuant to the procedure outlined in the Hyde Park local law, challenging the applicant's use of the Hyde Park parcel for access to the proposed development. This challenge has not been considered, or at least not decided by the Hyde Park Town Board, to my knowledge. I'm bringing this history to the board's attention because the applicant recently made an amended site plan submission and has asked the board to recommence its review of the application. We have also received correspondence from Mr. Raplansky, representing Common Sensus Hudson Valley, and concerned residents, contending that the application should not proceed before us because the conditions set by the ZBA in its June 2024 decision have not been met, specifically the requirement of a final non-appealable decision from Hyde Park granting access. Counsel for the applicant maintains, however, that the provisions of the local law and the language of the subsequent settlement stipulation in fact constitute such final non-appealable decision, said final non-appealable decision granting access, and that this board may now consider the application. And given these conflicting arguments, it is my view that the question, and this is for board discussion, just one vote, so I'm teeing it up for discussion. It is my view that the question of whether or not the conditions set by the ZBA in its June 2024 decision have now been met, allowing the planning board to proceed with this review, is for the ZBA, not the planning board. First, the ZBA, not the planning board, is charged by law with interpreting the zoning law, and in addition, and perhaps more to the point, the ZBA could not have foreseen the complex procedural path the matter has taken in the intervening 14 months since they issued their determination. Accordingly, it would seem to make sense to seek their guidance in interpreting their original decision in light of these subsequent developments. You have in your packets a draft, and there was a new version that came in.
It's on your new folder.
A draft and Shane can, if we need help interpreting it, Shane's here. A draft referral to the ZBA, and basically it just, it's going to attach the attorney's correspondence, including the Raplansky letter and the responses that we received from Mr. Stenger and Ms. Polidoro, representing the applicant, and basically requesting an interpretation stating whether or not this board's review of the application is in fact stayed by their June 4, 2024 determination. I'm going to open it up for board discussion, but I just want to mention one other thing. The applicant has requested some time after the discussion for a brief presentation of the highlights of their most recent site plan submission, and we've agreed to afford them that opportunity while our consultants are in attendance here tonight. But the presentation is for informational purposes only, and the board will take no formal action on the application tonight. So if you have the transmittal in front of you, that's kind of what we're talking about. Does anybody want to comment or ask questions, or go ahead?
So I just want to reiterate what Paul said, that I think in sum, right, we got a determination from the ZBA on this frontage question. They set a condition on our proceeding with the application, and I just think it's that the right thing to do is for us to go back and ask the ZBA, has your condition been met? That, in my view, that's not a function for us to decide. That's a function for the ZBA to decide. So I concur with the idea of sending this to the ZBA to see what they have to say.
Right there, yeah, push.
Yeah, it's.
There we go. I'm very sensitive that we not intrude on the proper functions of the ZBA, but I'm wondering if we can add a request in referring to them, that they act with dispatch or all possible speed or whatever, so that we have our marching instructions going forward as quickly as possible.
They have a meeting in August, right?
August 28th. 28th. Yes. For the ZBA, yes.
There's nothing else to do on the agenda for this, other than the presentation, other than deciding whether we're sending it to the ZBA?
Right.
Even
this
if we
is
said the condition's been fulfilled, there's nothing to do, like.
There was
nothing to do
nothing
to
we're gonna do. This isn't, this is a, you know, it's for our benefit, for our information, but Adriana and Peter here, so, you know,
Yeah.
it's just gonna highlight what they've changed. We're not gonna do anything until we hear, if we vote to refer to the ZBA, we're not gonna do anything until the ZBA makes a ruling.
Chairman, may I address the board while you're discussing this?
Just, is it the issue of referring to the ZBA, or? is
Yes.
it- Okay.
Yeah, it's topical.
Okay, we don't want to talk about the merits one way or the other, if you know what I mean. We have your letters and your letter, and
Okay, so you have my letter, you've read the law.
yeah.
The language is very clear that it isn't, the law is non-appealable. And laws, unlike administrative determinations, are presumed valid unless a court overturns them. You know, when a zoning administrator or Mr. Newman makes a decision, there's always a right of appeal. There's no right of appeal to a law. It's valid unless overturned. So from our perspective, you know, that is final non-appealable. What I'm concerned about is you refer this over to the zoning board, it's a big spectacle before that board, we're there for months, and the zoning board renders a decision, and that's appealed by the opposition. And now, what happens? Do you wait till that appeal's over? I mean, this is a doom loop that we don't see a way out of if we're always asking someone else to make a decision. From our perspective, this law from Hyde Park satisfies the condition on its face, and if we go back to the zoning board, we're going to create something that can be appealed ad infinitum. And Mr. Raplansky said that in his letter. He said as much. He's just going to keep appealing.
I think the use of the term non-appealable is potentially open-ended, I agree. And if we don't ask the ZBA what they meant by that, okay, you can only interpret it in the most open-ended way, right? Which would mean the result you're talking about would be a foregone conclusion. So, and I understand what you're saying, but I'm, you know, I think it's up to them to decide, you know, in light of these facts, kind of what they meant and how they want us to proceed going forward. That's my, did I get that right, or did I?
No, I agree, and I think we read your letter, I appreciate your argument, but, again, my feeling is, and Jack, I mean, I agree, this is not, we're not trying to slow things down, but I just think, I don't think it's for us to interpret their determination in view of what's happened over the past 14 months. I think it's for them.
Yeah, I'm aware of the possibility of endless appeals. I also understand, I hope, the difference between an appeal and a collateral attack. And I'm wondering, you know, once we hear from the ZBA, whether we have to stay our ongoing analysis, not a decision necessarily, but at least the process can go forward while any judicial proceedings go forward. I don't know that we have to wait for the courts to act. I understand that between boards of the town, we should defer to the ZBA, but I don't know that we have to defer further than that.
But can we make a sense of the board that says we either think that the condition has been met or that it hasn't been met, and we're going to proceed on that basis, but we're referring this to you, ZBA, to tell us if we got it wrong?
That would be consistent with what I have in mind.
We would really like to move forward. You know, it's been over a year since we've been before you, and we're back, and it feels like we're being sent away again.
I mean, I have real concerns about, again, it comes back to non-appealable. I think fairly read, now I'm gonna get into trouble, but fairly read, the passage of the local law combined with the stipulation, you know, does in effect clear the way for, you know, but the question is, but the point is it's appealable, right? That's the argument. And not only is it appealable, it's been appealed
Well, the
in a
settlement's
couple
not.
of different ways.
But
And-
it hasn't been
settlement's not been
appealed.
appealed. The settlement's
The
been
law's been challenged, but not appealed.
And that's, and
I knew I was
that's
gonna get in
exactly,
trouble.
and that's exactly our question, right? And we're, and it's a good suggestion, and Jack, again, I agree that we should try to move the application forward as we can, but we can't tell what the zoning board meant when they said non-appealable. I completely get your argument, right? But they didn't say non-challengeable. They didn't say, I don't know what they meant when they used the word appealable. Did they mean it in the legal sense, that in the very strict technical legal sense, is there some higher court that you can appeal to? Maybe. Or did they mean it in some broader sense, that the law couldn't be overturned somehow? I don't know.
I mean, when they made the decision, the Hyde Park ZBA hadn't ruled yet. Were they simply thinking of the appeal to the Hyde Park ZBA? We don't know. So only they know. That's our whole point. And I'm not comfortable moving. Here's the way I'm thinking about it. The order says it shall not proceed before the planning board, or words to that effect. You know, I think if the applicant, wants to proceed with consultant review of the new submission, which they pay for, and there's the risk that the ZBA comes back and says, what is it about non-appealable you didn't understand? That's what we meant, and everything. But I think the consultant review can continue while we're waiting for the ZBA. I don't really have an issue with that, as long as the planning board isn't involved. That's the applicant's risk, and it's their money. And I agree we should ask the ZBA to expedite the ruling. If they have to have a separate, special meeting to figure it out, they should,
Probably 2 meetings.
2 meetings.
It's going to be a meeting and then a public hearing, and I mean, we're
Yeah.
back to November.
We're gonna request to expedite, probably.
They can have I can tell you, I'm only one board member, but I can't, there's enough ambiguity in my mind regarding this that I can't go forward in a way. I appreciate your suggestion. I don't think we could move forward without at least some clarification from them. I don't know how other people feel. The consultant review can go forward. I'm talking about the board. And the next step is seeker, which is a significant step, so.
Yeah, so the ZBA decision says we can't proceed, right? So
Right.
I don't know, I mean.
There's no real room for maneuver there.
I mean, sure, I think we could do the consultant review. Maybe we could even start the seeker process. I think it definitely would be a bridge too far for us to actually vote on something substantive, right? But I don't
Sure.
think that
Well,
that's
like, what's
what you were.
proceed, right? Proceed to vote on something, or is it to just keep doing
Yeah,
information
and
sessions,
so,
right?
but
to speak?
and so I think what you were getting at is, well, maybe we can do all of the stuff up to actually getting
Correct.
to a vote.
Yeah.
Sure, that's fine.
I mean, and does it make a difference that the existing road is permitted? It's the petition filed by the opposition group really is on the secondary access.
Well,
I mean, I guess what's the
So we
appeal
either
that
got
we're
an
talking
actual
about?
site plan review or seeker review, right, but I think our prior conversations with you have been pretty clearly that we think that secondary access is very important for, emergency access, and so that's gonna be a critical part of our review. So, yeah, I think it's important to get a determination on that.
Okay.
Right, and the earlier feedback was the single means of egress wasn't gonna pass muster.
I mean, look, we're going to respect your decision. We understand the position you're in. But if you would agree to continue reviewing it and not taking action or voting, I think that allows us to move this forward.
Well, I mean, again, I think the consultants can certainly begin. I don't think you've had a chance to look at July 15 yet, have you?
I have, like, somewhat, but I think, Adriana has more than we do.
I mean, I don't have a problem certainly don't have a problem with that.
Sure.
Proceed at your own risk, obviously.
Yeah.
We're always here at our own risk. We know that.
Right.
And the escrow.
Yeah, the whole escrow situation.
It was replenished.
No, it was,
Oh,
but then I'm just saying to you, it's gonna up.
yes, we'll replenish as needed. So just,
Do you have a copy of the transmittal, the draft?
Do you want me to make a motion?
The new one? Is it
Yeah,
the new
so
one?
yeah, I guess you should make a motion for discussion.
So I would make a motion to the planning board that we refer a question for interpretation to the zoning board of appeals pursuant to Town Code 250-98C. And the substance of the referral question would be, as was in the draft memo. Do you want me to read it into the record?
You probably should, yeah.
Okay, so, the memo would be from the planning board to the zoning board of appeals dated August 5th, 2025. Request for determination and interpretation. The planning board is in receipt of a letter from Attorney W. Lansky dated June 25th, 2025, which asserts that the planning board's review of the above referenced project has been placed on hold pending CECNY's demonstration that it has the requisite road frontage and ingress and egress. The planning board requests that the zoning board of appeals review the contentions contained in Attorney Lansky's letter, as well as the contentions contained in rebuttal letters from Attorney Kay Stenger dated July 18th, 2025, and Victoria Polidoro dated July 30th, 2025, and interpret/determine whether the planning board's review of the CECNY Land Holdings LLC application is in fact stayed by the June 4, 2024 determination of the zoning board of appeals in light of the so ordered stipulation of settlement, index number 2024-53500, dated March 19th, 2025, in connection with this, I didn't add this, but I'll do it. This wasn't even bringing it at in connection with the Town of Hyde Park's passage of local law number 1 of 2025. See enclosures. The enclosures would consist of Mr. Lansky's letter along with Ms. Polidoro's letter and Mr. Stenger's letter. And this request is made pursuant to Town Code Section 250-98C1.
Somebody second it.
And I want to, and I would add in that the planning board requests that the zoning board of appeals act as expeditiously as possible, to render a determination.
Second.
I would just add, your memo just said on hold, which was different than the conversation. I just want to make sure you knew that what you read said the application would be on hold, so if you intend to amend it.
That was in Mr. Lansky's letter. That
Okay.
was his assertion that it was placed on hold. That was in quotation marks. That was,
Okay,
that's,
you were reading a quotation, understood.
Discussion, questions, concerns?
If-
Second?
I second it. If we send it to the ZBA and they say, this is what we said, and this is what we meant, and it's okay to proceed, are we okay proceeding on that basis, even if that is somehow appealed? Right, their own interpretation of their own words is appealed.
Anybody have any
yeah,
time
and
on
I
all
think
of
the
that, Bill?
process there has been, yeah, we
I think that's
proceed
the end of the
overstay.
process within the town. If somebody goes to court and asks for an injunction, that's up to the town to deal with when and if it happens. But until, once the ZBA's act, it seems to me, we're done as a town. It's up to the court to tell us to stop.
I agree.
And let the lawyers
You couldn't stop them
I
anyway.
just want to put that right there,
So if they, okay. I'll catch up shortly.
Their ruling is final until the court tells us not to act.
A stay put in place by a court. Because you can have appeals virtually ad infinitum, depending on how.
Which is the point that they raised.
That's
So my
the
point is,
issue.
right, there's one step,
Yeah.
you get one determination, and if it goes the way that they want it to, then we'll act. If it doesn't, that's a whole other issue, but it prevents the infinite stream of appeals.
Our ZBA makes the determination, is that what we're talking about? Okay. I'm hoping they're more clear than that, but yeah, I'm sure they will be. They will be. I'm not being facetious. Okay, any other discussion? Are we ready to vote on the resolution, Alex's resolution? All in favor? Aye. Anyone opposed? Okay. So, now it's, I think Kelly, you want to make your presentation?
Thank you, Mr. Chairman.
Thank you.
I'll just, again, before I start, just kind of hit the reset button that we did provide on the record. We did provide the new planning board member with a complete record of the submission that's been provided to the planning board to date. If you would like any of those documents printed, we're happy to do so. We're just trying to be cognizant of reproducing the entire package. So there is a flash drive that contains the entire submission and then all of the cover letters for your use.
You heard the discussion. I mean, you're free to interact with our consultants going forward.
Perfect, thank you.
While we're waiting on all the rest of it. Okay,
Which
go
we
ahead.
will
Thank
do.
you.
Before she starts, may I just ask one procedural item? Now that that petition was filed with Town of Hyde Park, could you authorize Arlene to send the circulation there so that at least that proceeds? That's just an administrative item.
Wait, I'm sorry, what is that?
It's a secret thing, and
You circulated for seeker, over a year and a half ago, but now we just want to include
so
Hyde
they're
Park
an
Town
involved
Board.
agency, is that the issue?
Yeah, they're now an
Yeah,
involved
yeah, but
agency.
hold on, I thought we were gonna resend everything, we're gonna start, no?
No.
Okay.
No.
All right, so you want us to just resend it now to the Hyde Park? Okay.
Just to the
To
town.
the town board, not.
Town board.
Hyde Park, Rhinebeck, right?
No,
Nope.
town, nope, Hyde Park.
Hyde Park Town Board.
Yep. And we have a copy,
Oh, okay.
we have a copy that we'll deliver tomorrow to your office. It's prepackaged, labeled, posted, and so forth. so you can
Victoria,
just-
you're just saying recirculate for intent to act as lead agency, or? circulate the
You've
actual
already declared
application?
yourselves lead
Yeah,
agency,
exactly.
but now that there's an additional involved agency, we just want to bring them into the loop.
Okay.
That's all. It's an administrative item.
They're involved in this petition process.
No, I understand.
I don't think
just
so.
know what she
They didn't
wants
have
us
any
to
approvals at the
circulate.
time.
Yeah, because I thought they resent something.
It's a new approval since they adopted this law.
Well, we wouldn't have circulated to the planning board in Hyde
But
Park,
not the town board.
That's the difference.
It's just an administrative letter, so
You're saying, so, because we did the planning board, not the town board, so now you want the town board.
Yeah, because they have to
Yes.
make a decision on access.
we'll give you another packet to send out.
And
Thank you.
I know there's multiple conversations going on. To your point, you were asking what we're circulating. We're simply providing the same documents that you provided originally, which it's generally the EAF. There's a cover letter and the site plan. So that's in the package, and we'll provide it to Arlene tomorrow so that it could be circulated. Okay, so we'll hit the reset button. Again, I'm Kelly Leibolt with KRC Planning Consultants. Amy Argerakis is here. I think everyone knows Victoria Polidoro, Rodney Morrison, and we're here representing the applicant, CACNY Land Holdings LLC. As you had indicated, Mr. Chairman, it feels like it's been an eternity since we've been before you, and it was actually March 25th of 2024, so it was some time ago, and that again is 2024. Since that time, we did make submissions to your board. We didn't appear before you, but we did make submissions. So there was a submission April 23rd, February 25th, and then the current submission here today. So I'll just go through the changes that occurred really on this current submission, but I just want to bring to light some of the additional documentation that we had provided to you. So just as a reset, so everyone remembers the project site, I think everyone is aware the location of this property. So the new address is 76-100 Millhouse Lane. That's the portion that's in the town of Clinton, which is 228 acres. That is in the AR3 and the AR5 zoning district. The portion of the property that is in, as you had indicated, in Hyde Park is 2450 Route 9G. That constitutes 8.2 acres, and that's in the Greenbelt District. And those areas are delineated on the presentation that I have given to you in the right, in the yellow. By the way, nothing that's in this presentation is new, so you've seen everything that's in this presentation before.
You have copies, yeah.
Go ahead, you have a question.
Well,
I
yeah,
thought there
it's
were-
been submitted to you.
Yeah,
it-
oh,
But
okay.
you might not have looked at it yet, so.
Okay, thank you.
So the site plan that was submitted on July 15th includes the items that are listed on the index of the drawings. Amy, if you can switch to the next slide. So this is the site plan that you have before you, and obviously it's a very thick package with all of the supporting documentation. As I had indicated, since we were last before you in March of 2024, there have been additional submissions. The information is fairly de minimis as far as changes to the site plan. The additional documentation that's been provided to you since March of last year, included a clarified building matrix. So we did provide you with detailed information about each building, the square footage, the height, et cetera. If you recall, we amended the lighting plan, so there were some hot spots before. We added additional landscaping. We added the event locations. We provided additional view shed information. And we slightly rearranged the parking area that is up by the equine facility. And Amy, I'm not sure if you're able to identify where that is or. No, boy.
Oh, here, I can, you want me to point?
Okay, so that's right, whoops. Here, can you, yeah. And the reason that we reoriented that parking area was just, it was a slight adjustment which minimized some of the grading. Okay,
It's not working.
okay, go ahead, you can flip. At the March 25th, 2024 meeting, we actually had an in-depth dialogue. That was a work session, if you recall, and the board really gave us a lot of great feedback on the site plan, and there were 4 major items that you brought to our attention that we've since addressed. So we really want to focus on those tonight because we responded to the items that you raised, and we want to go over those with you. So those 4 things were, first was the location of Cottage 15. And if anyone remembers, Cottage 15 was kind of up on the hill, and there were concerns about the location and the proximity to the wetland. So I'll go through how we've moved that. The second issue that you brought up almost a year ago had to do with the new wetland delineation, or the new wetland regulations. So at that time, it was 2024, and everyone knew that the regulations were going to change, and the board said, you know, make sure that you get a new reaffirmation of the wetland map from DEC. So I'll go over it. We did do that. I'll go over that. The third item that was brought up at that board meeting had to do with Blanding's turtle habitat. And I'll go over how we've addressed that. And the last had to do with the left turn lane, I think that you had brought up on Route 9G. And the board, even though DOT wasn't pressuring us to add the left turn lane, I think the board and the town generally said that they wanted the left turn lane. And so we heard you, and we've added the left turn lane. So I'm just going to go through those 4 changes. That's really the significant items to talk about tonight. So the first thing has to do with Cottage 15. So on the left is the location where Cottage 15 was back in 2024. Remember, that was up on the hill. We've since relocated it down, you can see on the right where it's circled with the red circle. That dashed line that you see there represents the 200-foot setback, so it is still set back 200 feet from the property line. This is a 2-story structure, very similar to some of the other heights of structures that you see, you know, residential properties throughout the area. We also amended the view shed analysis. So since we moved Cottage 15 down in that area, we have provided you, I'm sure you haven't had a chance to look at it yet, but we provided you with a complete amended visual analysis reflecting the location of that building. This just is a small rendering or a small image of what's in your site plan. So this was prepared by the architect. And again, there's a detail of the methodology of how this visual analysis was completed. So that was item number 1. Item number 2 that was brought up at that meeting had to do with reaffirming the New York State DEC wetland map. So we did it. We submitted the map to New York State DEC. We had incredible cooperation from DEC, and they reaffirmed and validated the plan on June 24th of this year, 2025. Just kind of some major items to go over what changed, right, between 2024 DEC map and today's map. So they did take the entire stream that runs along the property line between Hyde Park and Clinton. And we had anticipated that that was going to occur, so all of our development was set back appropriately, at least 100 feet from the edge of that wetland. So it really didn't affect the design of the project. They took the wetland that traverses the middle of the site. I don't know if you're using your finger, Amy, on the cursor, on that little pad, you might be able to show where that is. Yeah, right there, yep. So they took the wetland that was in the middle of the site, and they called that jurisdictional and regulated. They did not take the wetland that's up on the top left corner. Vanna?
It's dead.
They didn't take the top one? Okay, but, and most importantly is they didn't take the one that is in the, in between the development area on the site. So on the bottom left, they did not take that wetland. So those are non-jurisdictional. A full blow-up of that plan is in your site plan submission set, and so everything is labeled, whether it's jurisdictional or non-jurisdictional. It's signed by DEC, so that is the new wetland validation map. Okay, the third item that had been discussed had to do with whether or not the site constitutes Blanding's turtle habitat. So although there haven't been any records of Blanding's turtles on this site in over 48 years, so the last sighting was 48 years ago, and it was near the site, it wasn't on the site, the applicant has agreed to assume that portions of this site do constitute Blanding's turtle habitat. And predominantly, Blanding's turtles tend to occupy Hoosic soils, and so the Hoosic soils are contained in the lower portion of the site, and in the, I call them kind of the two fingers, where we're showing that development area on the bottom right-hand side. So we have already filed an incidental take permit with DEC. We're working very closely with the review team there to provide additional information that they require for the incidental take permit. And as part of that permit, we'll be required to provide some suitable area for turtle refuge. So we'll work with DEC to identify and confirm the location. Right now, we're proposing the area that is up by the solar fields because there is the inclination from Hudsonia that that area constituted great Blanding's turtle habitat. So we have submitted that application. A copy was provided to the town. I'm assuming that Hudsonia also has a copy of that as well, and we can work with them and DEC in moving that application forward. There's some raised eyebrows, so I just wasn't sure if there was any questions on that. No? Okay.
We're both getting old. But I've never seen a Blanding's turtle. That was impressive.
Yes.
Yes.
Yeah.
No.
So,
But not on the site.
Way back from the Duchess Reserve project. Sorry for that.
thanks. Yes. So the last recorded sighting was 48 years ago. But again, you know, we're taking the presumption that it's habitat, and we are going to process that
Right,
application.
so the applicant is voluntarily assuming that it's habitat in order to provide the most mitigation. Instead of doing the studies to disprove it, they're just assuming it's habitat, and then, you know, we'll go from there and try to make it better.
That's okay.
No,
That's okay. So that was the third item, again, that was brought up at the March 2024 meeting. So the fourth item that was brought up had to do with the left turn lane along 9G. And so again, the applicant took the initiative to submit an application to DOT for that left turn lane. Since it's been some time that we've been before you, we've actually been able to advance that drawing and the design in coordination with DOT. We have received a letter from DOT dated July 25th. I think the town also has a copy of it saying that they conceptually approve the location of the left turn lane. And so we're allowed to proceed to stage 2 of the permit process with DOT. If you're familiar with that process, there's stage 1, which is the concept. There's stage 2, where you begin to provide more details of the design. And then there's stage 3, where the DOT will actually issue the permit. As you know, none of the reviewing entities can issue any permits for this project until this board completes the seeker process. So DOT is aware they're only going to be able to take their review so far, and then they'll be waiting, like DEC, on the issuance of the town's seeker decision. This design and the submission to DOT also went to Brendan Fitzgerald, and I think you also have a copy of it. So your town engineer and your town traffic engineer both have copies of the submission that went to DOT.
Did we receive the copy of the, that you're on stage two from the DOT?
I'm sorry?
Did we receive the copy that you're on stage two from DOT?
Yes, it actually went to your traffic consultant. So the copy of the letter,
Traffic consultant.
yeah, your
Did I
traffic,
get a copy?
do I have a copy?
We can make sure,
Sure.
you have it.
Sorry. I thought that Brendan would have given it to you, but I'll make sure that you have a copy of it. Okay.
We circulated to DOT. no?
Yes,
Okay.
correct. Yeah. The left turn lane, we've done a lot of work with Creighton Manning, and the left turn lane is wholly within the DOT right-of-way, so there's no real estate transaction that it has to occur of like taking of private property. So the right-of-way here fortunately is very wide. The shoulder is also very wide, so all of the work for the widening is going to occur in an area that was either previously paved or the shoulder, all of which are impervious. So fortunately, there's no new impervious area that's going to be created for this road widening. So just kind of wrap this up is we did address the 4 remaining concerns that the planning board had, at least from the March 2024 meeting, which is we relocated cottage 15. We had the wetland map validated. There's no impact or changes to the site as a result of that. We applied to DEC for the incidental take permit for the turtle habitat, and we have completed stage 1 of the design and approval from DOT for the left turn lane. We also took the opportunity to send this new submission to the fire chief so that he had an opportunity to review it and see if there were any concerns that he had, so we could incorporate those. We did receive an email, and Arlene, if you don't have that, I'll get it to you. Okay, so we did receive an email from him saying he had no issues with the plans as presented. So you have that as well. So we kind of have checked that box. Okay, last but not least, I just wanted to go over, I know there has been a lot of communication and maybe misinformation regarding how much area this project constitutes and how much the development area constitutes on this site. So we just thought it was ideal to provide you with a plan that shows the areas that are being disturbed and the areas that are newly disturbed. So when I talk about newly disturbed areas, I'm talking about areas that have not been previously included in the existing conference center limits of work. So I'm just going to review this table quickly, and if you have questions, I'm happy to answer those. So, okay to proceed? Okay. So the total project area is 236 acres. So that's the entire holdings of this property. The existing conference center right now occupies 36.63 acres. So it's, just that lower portion. For those of you who have been here, it's that lower portion of the project. The limits of disturbance for this work, so what we're talking about here today, is actually inside of the area of the existing conference center. So it's actually smaller. It's only 31.82 acres. So again, the conference center occupies 36.63 acres. The limits of disturbance is in 31.82 acres. And so that actually also includes the work on 9G. So it's 1.49 acres. Kind of proof is in the pudding and give you this documentation and this mapping to show you. So the newly disturbed areas are 3.32 acres. So that's areas that are going to be encroached upon beyond the existing conference center. We've highlighted those. I know this is a little map, but I just, for purposes of your review moving forward and for the consultants, we can review this with them individually. So when you talk about the percent of the new disturbed areas within Clinton and Hyde Park, it's very small. It's 9% and 1%. When you talk about the percent of the newly disturbed areas of the entire project, it's 1% and 0.2%. So, we've been trying to implore upon you that this is a very de minimis impact in this area. This is work that's within the existing conference center. And again, we've talked about potentially having another site visit, and we can illustrate that to you if the board decides that they want to go out to the site. Amy, if you could just flip one more. So we tried to provide some aerial photographs, again, for those who haven't been able to come to the site, just to give you some perspective. So we did complete some drone photos, just to give you an idea of the imagery and the extent of the mature trees and the dense vegetation. If you could just go back one more. On the bottom left, you can see 9G, so you can see the extent of the dense vegetation into the site. The top left is the equine area, the barns, for those who have been on the site. Okay, you can flip down. This is, again, just looking at the upper portion, the northern portion of the site and the equine area. This is if you are looking south, so from the equine area, looking down at the site. And the narrowest portion of that vegetation on the site between 9G and into the site is 257 feet. So it's dense trees and vegetation that's in there. There's one more looking south, so that's one more looking south. And again, the areas that I'm talking about as far as the development are in these fields and in this area that's already disturbed. Buildings of the property and the minimal area that this development is going to incur, leaving that entire forested area up on the top of the hill in its current state. One more, Amy. And then what we did is just kind of a comparative of a blow up of the rendering and a blow up of the existing site so that you can see. It's easier for me if I was pointing. We can kind of go through this with the consultants in greater detail, but just to give you an idea of the perspective of where the development is occurring within that existing area.
I think, yeah, we're going to have an opportunity to drill
Go
into
through
this.
Sure.
You know, well, depending on what the ZBA says, but I, you know, it's an interesting analysis for us, so, but I think, you know, maybe there'd be a future opportunity to kind of go into more detail,
Sure.
if that's okay.
Yep. That really is a summary of, you know, our reaction to the board's questions and comments and concerns and how we've heard you and made all of these changes to the plans. The one thing that we did want to talk to you about was obviously that circulation to the town of Hyde Park, so I think we covered that. And then hopefully we can continue to work with the consultants to try to advance their reviews of the project.
I think the board is fine with that. And so it's been, oh, yeah, that's a good point. We should probably do a formal motion to circulate, to circulate to the Hyde Park Town Board. We should probably observe the formalities of circulation.
The additional
Yeah.
paperwork.
A motion to add the Town Board of Hyde Park to the,
Lead agents.
to the, yeah, to the,
Interested agents.
to the,
Interested?
they're involved, they're actually involved.
Yeah, involved.
Sure, I'll make a motion.
Do you have any idea what I'm talking about?
I'll make a motion to the town board, I'll make a motion to the planning board that we
Circulate.
add the town board of the town of Hyde Park to the list of involved or interested agencies to which we've previously circulated our seeker materials, and that we ask Arlene to forward to them a copy of the application materials.
Second.
Thank you. That's well done. Any discussion? All in favor? Aye.
Aye.
Okay. Anything else from your end at this point?
No, I think the only thing is we'll reach out to the consultants and include Brandon and see if we can do a Zoom or a meeting with them just to address any questions and so forth and concerns that they have.
Yeah, that's absolutely fine. So, and thanks for the presentation. Oh, we have a question. Go ahead. Just on mic, if you could.
I'm just curious, Kelly, since I'm one of your neighbors. On page 8, you show a rendering of the road or the access point to Route 9G. Is that coming through that Hyde Park property where the building's to be demolished? Is that where that is?
Yes, just to the north of it, correct.
Okay.
Yep. And that would be the new access road for emergency services only, so that's the new access road and the bridge.
And the main access is still going to happen where it's happening now?
Correct, but there's a slight shift of that entrance north on 9G just to improve sight distance and stacking, but correct.
Right, okay.
Yes,
So that, now I understand what you're saying about the widening, because that's already a wider area there anyway.
correct.
Okay. So what happens to the berm and everything that's in place there? Does that
I don't think that's
stay? Does that
Yeah, the
move?
berm-
Not
the
necessary?
berm stays right where it is.
Okay, so then your widening is really gonna happen over on the western side of the
It's
highway?
actually split between the two. The proposal is to, well, split the difference because you have poles on either side. So we're really only changing what is currently completely compacted road, gravel edge, which is impervious, into actual pavement. So it's, I think it's 3 feet on either side. But the forsythia berm stays,
Okay,
except where we break through it for the new entrance.
thanks for answering that.
Any other questions from the board?
I got it.
On the newly disturbed areas, you say in the presentation that of the 236, over 200 acres of property remains undisturbed in its natural condition. That 200 acres includes the area along Browns Pond?
Yes, it's that hill, it's that area really up the hill up to Brown's Pond, correct?
Thank you.
Yeah, for the record, there's no disturbance in the area of Browns Pond as part of this project.
Adriana or Pete, did you have anything right now? Okay. So that was really
Okay.
very helpful. Thank you very much, everybody, and,
I'd love to, Mr. Kelly.
Okay, thank you. All right.
and we'll,
Okay,
thank
thank
you
you for
very
your
much.
time.
Thank you for coming in. We're
night.
gonna, Brandon, we're gonna take a 5-minute break. Okay. Are we back on? So I lied earlier when I said the agenda was going to go in order. We're going to skip to the Lamagna lot line adjustment, 431, 439 Schultz Hill Road. Is anybody here for that? Please approach the table and have a seat. And,
The baby,
This
that's
is
the
a-
baby all about.
What a trooper.
wait, this is,
Beautiful baby.
wow, we got everybody. This is great. Yeah, whatever you want, you can,
So they're the
yeah, you
ones
got
gonna
it.
build them.
If you wouldn't mind identifying everybody, everybody at the table, we can, just so we have it.
I'm Dal Lamagna.
Oh, there's a microphone there?
You got it, that's got to have a green light on it.
Press the button. Yeah.
Just move it back a little bit from you.
Okay. I'm Dal Lamagna. I own Rhine Valley Farm, and it's my property on Brown's Pond that we're talking about tonight.
Thank you. And Mr. Dalbo?
I'm Michael Dalbo, the land surveyor for the project.
Excellent.
And I'm Liam Ripley, looking at purchasing the property
Oh,
from
okay.
Dal.
Okay.
And this is little Liam, Theodore, and my wife
Thank you.
Stephanie.
So we haven't talked about this one before, have we?
No.
Okay.
What did you get?
And board members, you have maps in your packet, right?
I'm sorry. What's
They have
that?
maps in the packet. Yeah.
I'm the one that I sent you.
Okay. So what's the plan?
Basically, we have a lot line adjustment between two existing parcels. The 2-acre parcel of land was created back in the 1950s. I'm sure the farm goes back much earlier than that. And the proposal is to add about 1.5 acres to this property. As the lot exists now, it can't meet the front yard setback, can't meet the rear yard setback, and if they did put a house on it, would have to be probably 25, 30 feet from the road, which would be unappealing to everyone. So what we've proposed is to move the lot line back. As you can see on the map, there are some trails through this property, through Dal's property, and that's about it.
Do you want to go with, or just?
Oh, sure.
Are there any, so go ahead.
No, so there's basically a giant lot that's 220 acres, I'm gonna approximate, and a 2-acre lot that runs along the road, Schultz Hill Road. I think there are a lot of small parcels kind of along that road, and so the idea is to take 1.5 acres from the giant parcel and add that on to the 2-acre lot to give them 3.5 acres. Now, it's an AR5 district, so we're not getting to the 5-acre, but it is rendering the lot, the smaller lot, less non-conforming, which is a good thing. Did I do that right? Less non-conforming?
Or more conforming.
More conforming?
One or the other.
They're both good, yeah.
Both good. And obviously, no impact on the larger lot from a conformity perspective.
And we have everything in the way of a survey, right? We don't need anything else.
Are you waiving something?
Yeah, there's a list of,
Oh, there's a list of waivers?
yeah,
There's a letter that's been submitted.
because it says you've got to comply with all the subdivision
Oh, yeah,
rules, and
that's
so
just-
it's waivers of the final and preliminary plat items.
So you're good to, as far as you're concerned, you're okay with it?
I have no issues with it.
No issues? Anybody else?
Do they then have to get an area variance when they want to build because they're in the AR5? Do we care about that at this point?
So the statute says that for the lot line, 20613 says the proposed lot line adjustment shall not create any substandard lot or render any lot more substandard than it may be. And I don't read it here that we're creating a lot. There are two lots. We're enlarging one, and the other one is not either going to be created as substandard or be rendered more substandard.
It's already substandard, we're making it.
You're making it
Less
better.
substandard,
Yes.
or more conforming.
And,
depending on how you
right,
look at it.
Arlene had sent some couple precedents, because in the past, we've had scenarios where like, there's a 2-acre lot and a 4-acre lot, and we took space from one, so that even though we enlarged one, we made one more non-conforming, and we had the variance there. In another scenario, we kind of picked off 2 pieces and made a new lot that was non-conforming, but here, the way I read that is to say, we're not creating a new lot, and we're not rendering a lot more substandard than it is. So I think it's.
Did you look at B2?
B, in the event the lot line adjustment proposes the creation upon the lots of any nonconformance with the local laws for which a variance would be necessary, the application shall be deemed to require a variance. Where a legal previous nonconformance exists, the planning board may encourage the applicant to remedy the nonconformance where feasible. The second sentence or the first sentence?
The first, nominally. So that if you do allow the lot to be created as a substandard lot, that will require a variance in order to be in that district.
But it's not the lot line adjustment isn't creating a substandard lot, right? That already
Right.
exists today. So
Well, yeah, that's right, that takes care of one, if it's read that way as creating. But if the lot line adjustment proposes the creation upon any of the affected lots, of any nonconformance. So one affected lot is still not conforming with the 5 acres.
Well, I read it as, right, the creation of any nonconformance. The nonconformance is, right, a nonconformity with the 5-acre zoning that exists today. So the lot line adjustment is not creating a nonconformance with 5-acre zoning. That's how I read that.
Yeah, I don't remember that. And there's no question that the resulting lot is still going to be under 5 acres.
Correct.
So it is creating upon the affected lot a nonconformance. It's not creating a lot, I'll concede one, although I don't necessarily agree with that either, but it is creating a nonconformance on the affected lot.
Go ahead, yeah.
So, Jeff, the only, I think that's a very maybe strict review of that. I tend to agree that the lot line adjustment needs to propose the creation of a nonconformity. In this case, the nonconformity already exists. And I would encourage you to look at the second sentence where a legal previous nonconformance exists on any of the affected lots. The planning board may encourage the applicant to remedy the nonconformance where feasible to do so. I think from an intent perspective, that second sentence is rendered not necessary if the first sentence implies that any nonconformity requires a variance.
Yeah, and same thing with one, right? If one was read the more broader way, it would say the proposed lot line adjustment shall not result in any substandard lot, period.
Period.
There's no need to differentiate between the creation of a lot or rendering a lot more substandard. So I think I do need to encourage you to try to do a 5-acre lot line adjustment.
To that point,
Right,
there's a little notch to the slight north. Can that be incorporated at all?
There's a bigger issue here. The couple here are from the area. They're trying to build a house. They like to live together in a home that they built. and they have limited resources, and every square foot we take from the 408 protected property, there'll be a penalty. And so by adding more land than they need, just adds more expense to the project to them. As you understand, we're taking land away from a 408 protected area. 408?
Land is on 408?
The big property is 408.
408.
So every square foot we take from there is going to cause some penalty, and it's land they don't need. I mean, they took what they need to make the house work. So,
If you just said result.
In other words, you're taking, if you had a 5-acre lot and you took an acre out of it, you now have a 4-acre lot, you've created a substandard lot, right? Or if it's,
Yeah,
or reducing the size of the substandard.
yeah.
I mean, I read number 1 as saying, is referring to the taking of land that results in a substandard lot rather than adding land to a already substandard lot.
I would agree with that.
Do you agree with that?
Yes.
Jeff, how do you feel about that?
I didn't hear it from you, sorry.
So, paragraph 1, the proposed lot line adjustment shall not create any substandard lot. That, to me, refers to the reducing a lot in size by taking acreage from it and thereby creating a substandard lot where it was already standard.
Right,
As opposed to adding-
Where it was already standard, that's the key, right?
Yeah,
Right, or saying, right, I've got 200 acres, I'm gonna carve off a 2-acre lot and
Yeah.
make me a right, that's a creation of a substandard lot.
that would be a creation. Or if you had a 5-acre lot in this case, you took
Giving
an
it an
acre
acre.
away from it, you now have a fort, that is now a substandard lot. That, it doesn't want you to do that.
Correct.
And it doesn't want you to take from what is already a substandard lot and make it even smaller.
Yeah.
Those are the two scenarios I think they're looking
Exactly.
at. Here, we're making the substandard lot
More.
better. Yeah, exactly. It's still, but
You're improving.
I don't,
I would agree with that.
you okay with that? Okay. So, to Alex's question, there's no risk that when they go to build a house that they're gonna have to get variances, right? Or how do you feel about that?
Well, that's the question. So, in the event that the proposed lot line proposes the creation by any affected lots of any nonconformance, there's an existing nonconformance of it being 2.0 acres. So the question is the nonconformity that it's less than 5, or is the nonconformity that it's 2 acres in a 5-acre zone? So when an area variance is granted, it's very specific to that property and to the dimensions that they're looking at. So if they grant an area variance for a 2.4 acre parcel, that's different than a 2.6 acre parcel, right? But it changes the law for that particular
Okay.
parcel. So
Okay.
I think the cleanest way to do it is an area variance, and that doesn't, have to add to the size of the lot or change the transaction between the parties.
Nonconformity is defined on, right, a use which fails to conform to one or more of the provisions of the chapter. So it's a
what's the-
failure to meet the AR5
Oh,
area.
even if we
However,
create
though,
law.
this subdivision, the lot line adjustment is showing a house location here. So in approving, just like when you approve a subdivision with a house location, you're approving a buildable lot by approving the subdivision.
Yeah.
That's the intent. Under New York state law.
On a less than 5-acre lot, that's.
Right.
This law is giving you the ability to approve a substandard lot through lot line adjustment that is made less substandard because it recognizes that you may be dealing with less than the sum of your whole parts, right? So you may only be able to partner with one adjacent neighbor to change your lot line in order to get your shed off their property or meet the setbacks that are required, but you're still making the effort to become less non-conforming.
I was just asking really, just a really practical question. We do the lot line adjustment, right?
Yeah.
Yeah.
He goes to file his building permit.
Exactly.
And Mike says, can't build on this.
You could build on it today with
Yeah,
variances, right?
exactly.
Or you'd say,
And if
yeah,
that's
it's gotta be
what-
20
and if
feet
that's
from
what
the
he's
road.
gonna say,
Yeah.
That's what I'm worried about.
and if that's what he's gonna say, oh, it was substandard before, you can build on it if it was 2, now it's, then fine, then I don't have a problem.
But even, it's a buildable lot, but there's no current building on it. If there were a building on it, then the setback envelope would be established by the existence of that building. But because no setback envelope is established on this lot, any new application would be subject to the
Well, but
bulk
that's
of
what they're trying to
regulations.
do, right?
They're
trying to
showing
add
setbacks that
property
Trying to
are
fix them.
conforming.
So,
So my question would simply be this: if we approve this, and they go to build a house, are they good to go at that point? That's all I really. I assume that's true. I assume they are, right?
Yeah, I mean, as long as you meet the setback, you're gonna meet the
Yeah,
setback.
as long as they meet it's a buildable lot at 3.5
Well,
acres.
they're
So,
gonna go for
okay,
the Department of Health, they're gonna.
okay,
go
yeah,
for
but that'd be true no matter what, you know.
Yes. And if
okay.
it doesn't meet the
I think we're
setback, then
good.
you're good, get it.
Okay. You following that? Why don't I try it?
Do you guys have anything for us, or yeah, I think we're in good shape.
Okay. Resolution, Town of Clinton Planning Board approving a lot line adjustment pursuant to section 20613 of the Town Code as requested by Dalamania LLC for two existing adjacent lots, a 2.03 acre parcel, tax grid ending 514 Lot A, and a 228.87 acre parcel, tax grid ending 359 Lot B in an AR5 zoning district, whereas the applicant seeking a lot line adjustment between Lot A and B in an AR5 zoning district to enlarge Lot A by 1.52 acres, which acreage would come from Lot B, whereas Lot A is a non-conforming substandard lot that, according to the applicant, was created in the 1950s. The proposed lot line adjustment would reduce the existing non-conformity of Lot A. Lot B is and will continue to be a conforming lot, whereas the planning board has determined the lot line adjustments type 2 action under seeker. No further seeker review is required. The planning board has considered and granted the waivers requested by the applicants from the requirements set forth in sections 20651 through 54. And after review of the application and sketch plan, the planning board's determined the proposed actions in compliance with the requirements of the town zoning law and town master plan. There are no known zoning violations on the parcel, and the board has received authorization to act for Dalamania on behalf of Dalamania LLC. Therefore, be it resolved, the planning board, hereby grants the application for lot line adjustment upon payment of all applicable fees.
Somebody second it? Did you get the waivers, or you got that, all right? Good, okay. Anything else from anybody? Do you need anything else we should put in there that you need? We can keep talking if you want, it's like, we love to talk. And type 2, okay, everybody ready to vote? All in favor? Aye. Anyone opposed? Thank you very much.
Excellent.
Congratulations, good luck with everything. Bye, guys, thank you, you've been great, you've been great.
Let's get some ice cream. We found a Stuart.
Yeah, I hope they're still open.
Don't tell my daughter.
Thank you very much. Thank you.
Thanks, guys.
Thank you. Thanks, Adriana. Safe travels.
Thanks.
Kids are gonna be tired.
Yeah. Okay, thanks for your patience. 4 Old Bull's Head Farm, 160 Old Bull's Head Road, variance recommendation. Hi.
Hi.
Sorry for the wait.
No, it's okay, and I don't know if I was prepared enough for you guys.
No, you,
But I brought a survey from Mr. Oswald.
and just introductions, if you wouldn't mind.
Okay.
Is-
I'm John Paul Avital, owner of 4 Old Bull's Head LLC. Grew up
Okay.
in East Fishkill, been farming my whole life. I plan on preserving the farm.
Okay, and just,
Yes, it
looks
is.
like I see. You may have been told, we just make a non-binding recommendation to the ZBA, and then they ultimately will decide on your variance.
Okay.
So it's sort of a two-step process. So anyway, do you want to just tell us what's going on in terms of the application?
Sure, there was a pre-existing structure on the property that I had fixed up and changing the use of that structure. So I believe I had to address that with you guys on that.
Okay, this is an existing, and it's, Jeff, this is changing the use to a residence, is that?
Yeah, from a detached garage to the residence.
Was that a garage before, or just a structure?
According to the county, it was garage, and there was garage door on it.
Okay, and it's a front yard setback, who's got this? Tom?
Tom.
All right, yeah.
Yeah,
So there's a little confusion. That's the confusion I came up when I was looking at this application. Because basically, when I went on parcel access, it basically said there was a Cape, in 2025, there's a Cape Cod house on there. So I was figuring out, well, what's going on here? Why is there an old house, no new house? called Jeff a couple times, just to figure out what's going on. There was a foundation there where the house that burned 20 years ago,
Correct.
right? So that's where the house was. This was the garage. The garage is right next to the road. So, it's about 11 feet off the road as opposed to the setback, which would be 100 feet. So that's kind of where I wasn't sure about the use variance versus the area variance. But I think if we stick with the area variance, this kind of all works out, maybe, depending on what the board, I mean, my recommendation to the ZBA is, the only problem, one of the other problems I had was that the application wasn't really complete, it was a little scant. I didn't get the ag district, the ag data statement, it's because the property is in
It's
an
a
ag
variance.
district.
You don't need it.
I didn't have Jeff's original denial,
You didn't have it?
No.
You didn't go to the laser test?
so, I mean, it was in my packet, I didn't have it, I don't know if anyone else had it.
Denial. What is your denial? Hold on. Check if you denial. I think there is a denial there.
Yeah, well, I didn't have it, so
Yours?
that was kind of the confusion with, I didn't know what was going on
I
here.
wish you called me.
Okay.
So, that being said, I got that all kind of figured out, but there were, I guess, like I said, the agricultural data sheet, some of those things, I guess,
The ag data statement, you don't need it. It's
can be
variance.
gotten later, I guess.
You don't need the ag data. It's a variance.
All right, but those are fair points, I think,
Okay.
just for future.
So, I mean, basically, I came up with a, you know, I guess a resolution
Recommendation?
for the
Hold on. Let's do discussion first. You wanna, tell them your intent. Basically, he's gonna build another primary house. This is just temporarily, and this is gonna become an ADU after.
I don't know how that's all gonna work out, 'cause if you're gonna call this a primary residence right now.
Well, I'm not sure as far as when that will be getting built, the new house. I'm working on getting funds together and so forth. It might be 3-4 years down the road from now. You know, right now, the main focus is getting the farm back up to par and getting it running and surviving again and the wheels turning. I'm looking to build, first of all, the barns were just, they were uninhabitable, and I have 4 little kids. I wasn't gonna have them run around there. So I took down the main train barn, and then we're gonna put up a new, the goal is to put up a new barn there. Same, not the exact same location, same area, just turned the different direction, because Old Bull's Head has no turnaround. So I wanna kinda create a turnaround in that area where, you know, forth. And then the other barn down at the bottom of the hill, that's gonna be the horse barn. So I'm gonna fix those up. I don't know where I'll be financially after I get that point. But the goal was, I am working with the Board of Health and Mark Day to have him kind of create, right now, we're just trying to find a location, another location for the house. My brother has, a disability and his daughter does, so if anything was to happen, I would let my brother have the front house. It wouldn't
Okay.
become like a rental or anything like that.
I guess that's all stuff that will have to be brought up later, but to make this work, this needs to be the primary.
Correct, and
Right now,
plus,
yes.
the other
Okay.
issue that we're,
So
For this variance.
Yeah,
it's the change of use that makes the variance necessary, because it's no longer, right, Jeff?
It loses its non-conformity.
It loses its pre-existing non-conforming status because you're changing the use. So it's 11 feet, it should be, it's been there since the 40s or something, right?
correct.
Yeah, but as a garage.
And I have the survey, and it's weird, because it's listed with the town as a garage, but they weren't utilizing it as a garage. There was a garage door, yes, 100%, but I mean, there was full bathrooms, kitchens, so like, that's what kind of threw me for a loop when I purchased the property, because it wasn't, like, you don't walk in there and it's just a shell. It was like walls, plumbing, electric. I mean, you have 600 amp service coming into that building.
Yeah, but it doesn't mean like the previous owner illegally, renovated like that. It doesn't
Okay, but
mean-
that's not our,
Yeah,
right,
no,
that's,
I know.
the building, doesn't the building department have to worry about that, or, you know, that kind of
Well,
thing?
no, it's already in the process of,
Okay,
and he's gonna get a special permit when he does the ADU.
Yeah, and I mean, whatever permits I need to get, I'll
yeah.
absolutely have taken care of. I want to have everything done, you know, accordingly. And the property brought up to par. I know that's been abandoned for a while over there. So I think that was
I'm
like
fi-
the
I'm okay with
eyesore.
Yeah, no, but, and that's, I think part of my recommendation to the ZBA is that you do have the C of O and the health department has to sign off on that, right? I mean, if it's gonna be a primary dwelling, you need the bathroom.
Yeah,
you need-
we need a 1034. to be
Yeah.
done.
And they came, the health department's been on the property.
Mhm.
So, we did some test holes, but the septic system itself has been existing since the 40s.
So before we could make that a primary dwelling, we need the 1034, because we don't have a record of septic on that thing. So that's another building
Okay.
department procedure, so.
It's
we're only
really, yeah,
doing a
all we're
variance.
doing is the variance.
That's gonna
Yeah,
get
we're only
figured
doing
out.
variance.
Yeah, all we're doing is the variance right now.
But in order to, we have to consider that the primary residence.
Yes.
I mean,
Yeah,
that's-
but right now, we're only doing variance. Let the
And-
building department do that.
And you're worried, and what we're worried about is the setback
Exactly.
for that residence. So,
Anybody else, anything?
That being said-
Do you have something you want to read, or how do you want to do this?
I mean,
You could just summarize it, or however you want, yeah.
pretty much summarize it. I mean, some of the specifics, maybe on, this is a 23-acre piece of property, it's not in the it's not in the critical environmental area, it's not in the scenic or historical overlay district. I think, because the maps are impossible to read, but I think it's in the, within the ridgeline protection overlay. Because it looks like it, from what I saw on the sheet that he had there, it's
Sure.
about 500 feet. And
It
That's
does-
the cutoff, right, 500 feet?
Yeah, I mean, it doesn't really affect
That doesn't
this.
affect anything.
Yeah,
Anyway,
anything, yeah.
that's- I'm just throwing
No, it's
it
good,
out.
that's good.
It's hard to read on that. That this proposed variance is not really gonna have an adverse effect on the, or impact on the physical environmental conditions in the neighborhood, because the structure is, there's residential dwellings in this area anyway, so it's already there. It's not like he's creating something new. I do believe, though, in your application, you said the difficulty was not self-created, but I believe it kind of was. It's debatable. It was there, he thought it was a house, but what could happen is he could build on the existing foundation if he wanted to put a house somewhere. And like, instead of doing
It's-
this.
yeah, it's
So
self-created.
It could be done, but it would
Yeah.
cost him a lot of money.
Yeah.
And it would kind of counterproductive, so I think what we're trying to do is get where he's living now, kind of in conformance. And so, basically,
Are you in the positive,
yeah.
a
well,
positive camp?
so, yes, I basically said the resolution was a positive recommendation for the zoning board of appeals on requested area variance. Section 250, attachment 2, which is the bulk regulations, make the existing accessory structure a principal building with a setback of 11 feet, which is required for the 100-foot setback. The only other condition, I think, for the zoning board would be that the health department approval with the final septic and other approvals from Dutchess County Department of Health before you issue any COOs. I think you need to get that straightened out.
Before the
If you're
building.
gonna make this primary residence,
Before the
you should
building.
have that.
Before the building permit.
Okay.
Yeah.
You can put it in, it's
I
fine.
think, also, we should say that there's no external alterations that would increase the nonconformity. I'm gonna get in the weeds with that, but for any future expansions on that garage/house. So if in the future, he goes to like put an addition on that, like that would trigger and require maybe a separate variance.
That's true.
Because it's gonna be a house, and then you're gonna say, well, it could be a little bigger, or I can put this on there and that on there, so I think that's one of the things that, we should require.
I'm sorry to interrupt, but once an area variance is granted, that area variance applies forever. So if they change the front yard setback to be 11 feet, the front yard setback is 11 feet. So the non-conforming status of this building goes away, it becomes a conforming structure on this lot. So he could expand that to whatever, as long as he doesn't go closer than 11 feet to the road.
And basically just maybe a record, other restriction, basically the cover of record in the county clerk's office stating that the variance applies only to the existing structure.
Okay.
The variance is on that structure.
What?
Is that usually
Yeah,
standard?
that's it, yeah.
So the variance only applies to...
It's not like, it's not a line that goes all the way across the front of the
No,
property.
it's-
Yeah,
Okay.
that's right.
Basically.
So that's your motion?
My motion.
Motion
Yeah,
to
positive
adopt that
recommendation.
okay.
Second?
Who's the second?
Second.
Thank you. Discussion, what was the only other thing, I'm not gonna prolong this, the 2025 building on parcel, what is
I
that?
saw that too.
That's the building he made. So they just, he was outside working on it when the assessor went through and.
Okay,
did the site
that's
visit.
what we're talking, the 11, that's the old garage thing that,
Yes.
okay, gotcha.
Yep.
I can't believe they put it in there already.
Yeah,
It's already in there.
they got me. I don't know what happened, and
Not yet.
also the yeah, yeah.
It illustrates the difference between assessor and zoning. The assessor has their own codes, and they will assign a residential code to something that may or may not actually meet the zoning for residential.
You know what they do is they go on the property and they visualize and they assess based on what they see.
Yeah, well, they definitely got me good because they changed the taxes on that property pretty quick.
All right, so, did you have something, Jerry?
No,
Okay.
it's just, I agree, that site one, it says was built this year, and it's 2,000 square feet, and then site one improvement was built in 1950.
It's weird.
For 4,800 square feet.
It's
Yeah,
kinda odd.
backwards, I think. So, yeah.
But we'll get it all corrected, and whatever you guys need from me, I'll make sure we'll get it taken care of.
Okay, so what we'll do, we're gonna vote, anybody other comments? Positive rec, all in favor? Aye. Opposed? Anyone? Okay. So now you're gonna have to go to the ZBA, that will be in
28.
late August.
Okay.
And, Arlene, you can coordinate with Arlene.
Yeah, yeah.
I don't know if they're gonna want pictures or something. Do they
Yeah,
usually want
send
pictures?
of-
Okay. I sent some, but I'll get a bunch more.
Yeah, more is better.
Okay.
All right.
All right. Thank you, Chairman. Thank you, board members.
Thank
And,
you very much. Good luck with the,
Thanks.
the new
I'm sure I'll be
farm.
seeing you guys again soon.
Yeah, yeah, we'll see.
Thank you.
All right, have a good night. Sorry we ran so late. All right, sorry, Valley,
Yeah, really nice young man.
331 Mountain View, site plan, special use permit.
All right, Jack.
Jack's up.
So sorry that you drew the short straw on the last on the agenda. They were, oh, okay. I was worried that they were, thank you for remembering that. Just for Arlene's benefit, your names for the record, if you wouldn't mind, please.
Okay. Brian Veely.
Thank you. And you are, just a general idea of what you're doing, I think we just talked about this last time, but just so we,
Yeah.
recollect.
My parents own a home on Mountain View Road. They have an apartment, well, they have a garage, and they built an apartment over it, and we're trying to get it in compliance.
And you got the variance for from the ZBA.
so this, right, Jack, this was two variances?
There were two variances. You
Yeah.
made a recommendation, ZBA has now approved, now they're back here on the ADU itself.
Okay. And did you have anything you wanted to highlight
A
from?
couple of things.
Okay.
There's a lot of paperwork that normally would be part of this, isn't here.
Okay.
And all we need tonight is set a date for the public hearing.
Yep.
And at that time, assuming the public hearing is not controversial, we can act on the application. But before that happens, there's some paperwork at least that has to be released.
Okay.
Most importantly, you have to have proof that this meets Board of Health standards for plumbing. If you have something from Board of Health itself, that's great. If you don't, we'll take a letter from a certified engineer saying the plumbing works, that it's all fine, it meets Board of Health standards.
Yeah, that's in the works right now, so I'll get it for you.
We can't go forward without that.
Okay.
It would be nice if setbacks clearly. It doesn't yet. Particularly, it's hard to figure out what the front setback is. The building permit that says the setback from the front is 114 feet, which is fine. It's a 100-foot requirement. Show the distance on the drawing itself.
Okay.
Third thing that I thought, is there an application for an ADU itself as opposed, all I have is the variance application.
I sent it from the one before, from the, with the
All I have is-
recommendation, the site.
Yeah, there's a special
permit.
use permit.
The site plan and
There's the
special
applications
permit.
there?
Yes,
Okay.
Do you need one?
So
Okay.
those are the two main things that I think
Yeah.
you need.
So you didn't give it to him?
With that
We sent from
understanding,
the
we
previous
can make a motion to put it on the calendar for whenever.
Okay.
Okay. Oh, the 8 this says the 8.8 acres, right? That was one of
Instead
the.
of 10. I'm just curious.
Instead of 10, and then the square footage.
Yeah, so they got those. And there's no separate ADU application? for
There is
that?
a site plan and special permit application. It was sent in the previous.
Do you want mine, Jack, or?
No, it's okay.
Mine has Jeff's notes on it.
Okay, Arlene will get
Yours
it.
too, yeah,
Okay.
yeah.
We have
Yeah.
Okay, so with that, I make a motion that we set this down for a public hearing and appropriate action at our next meeting in September.
Can you make September 2nd?
Yeah. Yep.
Do you wanna show your, map? Because that's the map that he has, is
Yeah, I don't know what,
his,
We just have a drawing.
what's the drawing that he got?
We do a positive or a neutral?
What's that?
Remember if we were positive or neutral?
I think we're positive.
Were we positive on the recommendation division?
I mean, they're just, it's an existing.
Didn't someone just have a big one that we were neutral on, an ADU?
Not this one is because it's from eight
It's
point
like
something to
existing.
10, yeah.
It's like an existing building.
I'm just curious to hear how they
Yeah, no, they were
deal
fine.
with our neutrals.
They were fine.
They get all
The
I know
neighbors.
they get cranky, but.
You made a motion, right? Somebody's.
Second.
Thank you. So this is just to set the hearing for September 2nd, works for you guys.
Yep.
And you'll need the information and documents Jack asked for.
Yep.
I can't think of anything else. It's not it's a type 2, there's no seeker. Anybody have anything else, or? No. Anybody have anything else? So all in favor, this is just setting the hearing, September 2nd. All in favor, aye?
Aye.
Okay. So we'll, yeah, we may be in the smaller room on September 2nd, that's the other building, but I think you were in there last time, so we won't necessarily expose you to this situation. And I'm hoping it'll be a shorter meeting and you'll go, and actually, hearings almost always go first, so.
okay.
So, okay, great. So thanks for your patience.
Very good.
Have a great
Thanks.
evening. Thank you.
Motion to adjourn.
So Catherine, do you have comments for the board, or? You want to come up, or?
What's coming up would be that the wetlands law will be introduced soon. The provisions, I should say, of the wetlands law are going to be introduced soon, and then Elliot submitted his revision, proposed revisions to the hotels and conference centers. And I think Paul made a plan with Elliot, correct me if I'm wrong there.
Wait, you're on TV, you wanna put on microphone? I can't hear you.
Oh, boy.
I can't hear you.
She's had a long day.
I'm sure Paul will fill you in on the plan for the hotel and conference center revisions as far as what your opinions are. If you feel so moved, you may certainly comment individually. He's hopeful that it to be introduced in September, but I don't think that's realistic, so.
Okay.
But
I think
that's really just how-
I think we'll allocate some time at the next meeting to go over the hotel thing, as a board.
Have
The
you read it?
ZBA is
I
already.
read it, but I have to go back over it.
ZBA
Yes.
already.
Can you set the stage, just set the stage for like what is trying to be changed or what the
The
reasoning
biggest
is?
change, on my first very quick
Yeah.
read-through, my thoughts are the biggest change is conference centers are no longer allowed. He moved hotels from Hamlets to, it was AR
maybe 3 and 5 to a larger parcel district, I'll say, and that there are some parameters to how many guests and things like that. Now, that is my first cursory read-through, but you'll have time, because you have until September meeting, take a look at it, you guys can talk about it and make some recommendations, and even if it gets introduced, there will still be time for you to comment on it before anything happens, because as you know, these things take a lot of time.
Yeah, and I would just add, that's right, and Alex has already pointed out that basically, there would be no kind of event venues except in a hotel.
Yeah, the effect by getting rid of conference centers, there's no standalone event venues.
Well, but you've also written a law that pretty much guarantees that there'll be no hotels.
And it is quite restrictive. I wasn't gonna go there, but it is a little.
You can have a restaurant, but your restaurant can't serve anybody that isn't staying in the hotel, and oh, by the way, you can have one wedding a year. So let's all go build a hotel.
Right, so your recommendation may be, don't bother with all the verbiage, because really, just do what you, just say what you want to say.
Get some balls.
If that's.
We're on TV, guys.
Right, 1 and 2. Now, my only caveat would be, ag, those ag.
No, the ag event centers.
It's a separate thing, right? That's a whole nother.
That's for the farm.
I think, like in our little committee, we had talked about the concept of a country inn as something everybody can get behind, and the question is, how big can they be? Where can they be situated? Like, one of the good things in the draft is they can only be on a state or county road, so they can't be on, Schoolhouse Lane or something. They can only be on a street that can support it.
Yeah.
But I agree with the sentiment that if you're going to make it so restrictive that nobody's ever going to do it, you might as well just say we don't allow it.
Yeah. Shane's view is that it's more defensible to have permission with high restrictions than a total bar.
Oh, okay.
I agree with that. He raised that as an issue.
However, I hear that, and I don't disagree with it, but it makes a lot more work for boards like yours. If it's just
does,
is or it isn't.
You're just going to have people coming in saying, can we have a variance?
Right.
Exactly.
Right, but.
Catherine, can I get a copy of that?
Yes, certainly. So that, I think that's really, those are the things coming down the pike that you want to pay attention to, and you have time.
Okay, so
Anything-
I'm hoping we'll have a shorter meeting, and we'll be able to, I can do an email. I'll do an email that basically just lays out some of the, to your question, lays out just some of the features of it, and just says, okay, how do we feel about this? How do we feel? Because there's also some things in it that as a planning board would be difficult to deal with. There's something about open space, wetlands, steep slope, pretty much every type of terrain you can think of shall be preserved, and you're kind of like, how do we deal with something like that? Does that mean we only can develop in a forest? Because that's not included on the list, so,
Right.
I just think some of it.
Trees.
Yeah, well,
There's a clear-cut
I just,
Sorry.
I don't,
Was
anyway.
there a rule that we said one time about moratoriums, like how long they can be on things?
Yes, the
Like 6 months, yeah.
moratoriums are 6 months, and they can be extended another 6, so it's a year total.
Okay. Just, every time we have these changes, it just reiterates to me that we have to finish the zoning law and do a new comprehensive plan.
Yes, well, in that regard, LA and I have already started talking about how to get the comprehensive plan going, and we are accepting names of people that would like to be part of that process. So that as soon as, so actually, what I would really like is that we are ready to go.
Yeah.
So as soon as that's passed, we can start, maybe even start with the sort of organizational pieces before the zoning is passed, because that is really, I think you're right, that's the problem. Well, one of many, but that's the thing. We need to have a really good guiding principles so that we can move forward, and have a much more streamlined review of zoning, because that just, lots of reasons. It took too long, and it's gotten convoluted, and it's not a good situation.
Hire a professional to write it all.
Well, the nice thing about that is that you all have created a great relationship with a really fantastic planner. So isn't that going to work to our advantage?
Yeah.
Oh, that was a conversation, trust me, that's already a conversation that's been had, so.
That would be great, yeah. And the moratorium, that's going to be discussed at your next meeting?
That,
or-
I believe, will be on the agenda to be voted on. I think
Okay.
that's where we're at in the process. It will be voted on, as presented.
Excellent.
What's this next week?
So I think we're good, right?